Illinois' gun ban remains in place, but gun rights advocates say the law's days are numbered. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop with the Center Square and America's Talking Network. Be sure to like, subscribe, and hit that notification bell to stay updated with daily updates. And yesterday, big day at the U.S. Supreme Court. It was a cleanup day, but as you can see at thecentersquare.com, Illinois' gun ban remains in place, but rights advocates say the days are numbered. Yesterday, we reviewed the Supreme Court order, and this is on a case that several cases from the Southern District of Illinois and the Northern District of Illinois had different outcomes and preliminary injunctions. And these are just initial requests, not on the actual law itself. That remains back in the lower courts in the Southern District and the Northern District. And the Southern District has a bench trial set for September 16th. So that is going to proceed after yesterday. The U.S. Supreme Court, and specifically Justice Clarence Thomas, declined to take Illinois' challenge of the gun ban under consideration, essentially saying that it's not ripe yet. They don't have a final judgment yet. And that final judgment can only come from the district courts and then going up to the appeals court to be dealt with one way or the other. But Thomas was clear in his order yesterday that the Supreme Court is willing to take this case once there is final judgment, and even criticized the Seventh Circuit Court of Appeals ruling that the state had a likelihood of winning this case, comparing AR-15s, commonly owned semi-automatic firearms, to being akin to militaristic type of firearms. So yesterday I connected with Hannah Hill from the National Foundation for Gun Rights, and she said that it was a mixed bag of a ruling that came out yesterday that essentially keeps Illinois' gun ban in place.
The Supreme Court did not say no to the issue, though. They said no to the procedure. They said no to where the cases are at procedurally. But Justice Thomas's statement made it very, very clear that they will be deciding an assault weapons ban case eventually, and that the Seventh Circuit got it really, really wrong. He used the term nonsensical, contrived, highly suspect. And he said outright, it is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. Those are strong words from a Supreme Court justice. Seventh Circuit got it wrong. There's no doubt about that. We've said that all along. Justice Thomas echoed that. And the Seventh Circuit knows that. And Justice Thomas gave us all hope when he said that basically go through the merits. And if the Seventh Circuit remains obdurate, if they say the same thing, we're prepared to take the case. It's not an outright promise, but it's strongly signaling that. And we saw that echoed with how many times they relisted it. This case has gotten traction. We've been banging on the Supreme Court's doors on 3 separate occasions. All 3 occasions, we never got an immediate no, and we got some level of engagement from the justices. They've been watching the issue. They see the importance of the issue. They see the unconstitutionality of the ban. And we're confident that they will take a case and that they will rule correctly. They will strike down assault weapons bans when they finally do take that case. That said, it's very disappointing that they didn't take this one. I personally, obviously, as you know, we're the plaintiffs in one of those cases, we think that they should have taken this one. It doesn't make sense to us that when they see just how stubborn the lower courts are going to be over applying Bruin, the Seventh Circuit's ruling was not a good faith ruling. So when they see that, what does the procedure matter? That's where I differ from what the Supreme Court was communicating. There are times to say no on a procedural basis. I don't think this was one of those times, but I'm not a Supreme Court justice, so it's not my call.
So again, Hannah Hill with the National Foundation for Gun Rights, in my conversation with her yesterday, and that conversation came after we got a slew of responses from gun control advocates. They heralded the decision from yesterday. In particular, you've got John Schmidt from the Gun Violence Prevention PAC, GPAC, that said the Supreme Court action means the protection of Illinois citizens from assault weapons and large capacity magazines will remain in effect. That's good news for us all. You also have the likes of State Representative Bob Morgan, who made comments as well about this issue, and ultimately saying that it means weapons of war are going to be off the streets. Another gun control advocate, Yolanda Androzo, executive director of 1AIM Illinois, acknowledged that it keeps the ban in place, quote, at least for now. And she says further, as for the fighting over this law, it continues in district courts. We remain steadfast in our commitments to advocate for sensible gun control measures that safeguard our interests, Androzo said. Hannah Hill with the National Foundation for Gun Rights, I asked her if she feels that they understand the implications from Justice Thomas's comments about the law, who he said it was suspect, and even criticized the Seventh Circuit's ruling as to not falling in line with previous precedents. And Justice Thomas even went as far as to say it's clear that they need to make things more clear as to what types of firearms can be regulated. But Hannah's reaction to the comments from gun control groups.
So for them, a right delayed is a right denied. And so the temporary victory today is one they'll take. And that is something that the Supreme Court should have thought about. The Supreme Court should have realized that to say no on a procedural basis does delay the rights of Illinois citizens for at least another year. That's not okay. They've said that's not okay with other rights. And that is one of the reasons I disagree so strongly with their decision to say no today. Because yes, it was over a procedural ground, but the effect of the decision is to allow the Illinois government to continue trampling on the rights of its citizens. In no book is that okay. However, no, to answer your question, they didn't read the words of Justice Thomas, but they also don't care about the words of Justice Thomas. They don't care about the words of Bruen. We've seen that over and over and over again. Remember, the Illinois statewide gun ban passed after Bruen. If they cared about justices and what the Supreme Court has said and the rule of law, they would never have passed it in the first place. So that's why we have to outlast them, and we're prepared to do that. They know we're prepared to do that. So their victory lap is going to be very short-lived, and they know that as well.
And the timeline of all of this, obviously, rather fascinating, with the governor having signed this back in January of 2023, lawsuits filed shortly thereafter, going through the process on preliminary grounds with initial requests in the Southern District and the Northern District, different outcomes going to the appeals court siding with the state on those preliminary issues, and now the Supreme Court saying, listen, you got to get final judgment on this. So it's back to the Southern District of Illinois federal courts for four of those cases. Four of those cases have a bench trial set for September 16th down in East St. Louis with Judge Stephen McGlynn, who back in April of last year gave a preliminary injunction against the law that was ultimately overturned by the appeals court only 6 days later. But that gives you an indication of McGlynn's sentiment here, who's also said that he plans on moving forward expeditiously on the merits to get that final judgment. So a bench trial September 16th, but you've also got action up in the Northern District, and that's where Hannah Hill with the National Foundation for Gun Rights has the Beavis case. They're representing Robert Beavis from Law Weapons in that case, and that's in the Northern District courts. And actually, that's a case that was filed back in November of 2022 before the state of Illinois passed a gun ban. So Hill gives a bit of an overview of that case and a bunch of other cases with similar postures across the country.
Northern District. And if we had remember when we filed this case, it started with just Naperville because there was no statewide ban at the time. Naperville is in the Northern District. That's why we're there. That's why we're in an unfriendly court. With a statewide ban, you have the option to bring it in the Northern District, the Central District, or the Southern District. So they rightly chose the Southern District as the friendliest venue. And that gives us options, right? Because we're challenging it in a variety of courts, even within the state of Illinois. So we're excited about how far ahead they are. We're going to continue fighting in the Northern District. And the Seventh Circuit is going to have to weigh in a second time, this time with the words of Justice Thomas ringing in their ears. And if they double down on this ruling, and honestly, I expect them to, um, I think I think the Seventh Circuit knew exactly where the Supreme Court was standing, and they signaled with that ruling that they don't care. They're not going to care now about this. So they are ripe for another smackdown, and we're happy to help deliver that when the time comes. So we'll keep fighting. We also have 5 other cases throughout the country in a variety of procedural standpoints. We have 2 in Colorado, one against the Colorado magazine ban, another against an assault weapons ban. Both of those are going through the summary judgment phase right now. And we hope to have at least one of those in front of the 10th Circuit this summer. That's our hope, certainly by the fall. And so you have those cases. You have 2 cases before the 9th Circuit right now in California. You have the 4th Circuit case currently. Both the 9th Circuit and the 4th Circuit, both of those have had oral arguments, and we're waiting for a ruling on those. So it depends on how much they're going to slow roll them. Then you have our Colorado case currently at district court, heading soon for the 10th Circuit. So we have vehicles to challenge this policy, prepared to go to the Supreme Court, hopefully within the next year. And if Illinois doesn't beat us back, if the 7th Circuit doesn't go back to the Supreme Court, then one of those hopefully will be the vehicle that the Supreme Court uses to say that gun bans are unconstitutional.
So we, of course, will be watching all of this as to the trajectory, where it goes, and who's going to have the first case to actually fully get to the U.S. Supreme Court. Could it be an Illinois case? It's obviously something we'll continue to monitor. And subscribe, hit that notification bell. Illinois in Focus Daily here with the Center Square and America's Talking Network. Subscribe, hit that notification bell. And when it comes to the state's defense of this, Illinois Attorney General Kwame Raoul said he will vigorously defend the gun ban's constitutionality. He says that the law is an important part of what must be a multifaceted approach to addressing gun violence, and I'm pleased it remains in effect in Illinois. But of course, defending this law is going to cost Illinois taxpayers as well. We'll have to do a deep dive into just how much it's cost taxpayers to defend this. So subscribe, hit that notification bell. Illinois in Focus Daily. I'm Greg Bishop. Thanks for hanging out with us each and every weekday morning.